Black Doctors Podcast.
Hello, welcome back to the Black Doctors Podcast. I'm Dr. Stephen Bradley, your host. So excited to have a recurring guest on the show, Michael Johnson of Michael Johnson Legal. Man, we feel like old friends. We've been on this since the very beginning. It seems like you came on an excellent, probably one of the best performing episodes of the podcast, where you just talked about contract negotiation. So Michael, welcome back to the show.
Thank you so much. I have a special thanks to you too. When that first show dropped, that really spurred the Instagram growth and really gave me a starting point for a platform to talk about physician contracts, talk about career goals, life plans, and try to provide as much free education as I possibly could. And it really started with this podcast. So thank you for that. I really appreciate it.
Awesome. Well, Michael, for people that may not have listened to that previous episode, which I'll put a link in the show notes so you can go back and listen to that episode, can you just tell us about yourself and how you got started in physician contracts? Because you have a very unique, very special attachment to the field.
Yeah, it's around this ring right here. So a little background about me. I'm a lawyer. I own a small law firm, Michael Johnson Legal. I'm also creating a course on physician contracts that's coming soon. But I came about this through my wife's personal experiences and kind of seeing it from the other side, from the med spouse side. About 8 years ago now, I was swiping around on Bumble and matched. Literally the
whole story.
Literally the week before match. So like first couple dates were match, and we were engaged and married soon, and then starting to look at contracts, and it was just super confusing, even for a lawyer. Okay, that's married to a physician, it was really challenging. There wasn't a lot of information out there, and we kind of learned it ourselves. There's some folks focusing on this on the physician side. Plenty of lawyers doing this for private equity, for hospitals, for large private practices, that sort of thing. But wanted to create a law firm that was really geared towards helping individual physicians as they're evaluating and negotiating all the different contracts between their work. You know, and then we obviously went through it as in my own house. And then we were also part of that 40 to 50% that changes jobs within the first 5 years. My wife changed jobs, so we went through it again. And, you know, through those experiences, I wanted the firm to be a place that individual physicians could get sound counsel.
Perfect. Full disclosure. So there's one, let's see, this is not legal advice. Number two, I actually haven't used Michael's services personally, but having talked to him extensively in podcast interviews, I did feel empowered, and I learned enough to be able to navigate the generic contract that I received. And I've had quite a few friends that have taken advantage of Michael Johnson Legal, and they've spoken highly of their experiences. So thank you for the quality work that you've been providing, and again, for the knowledge, information that you come on the show and share.
Thank you for the kind words. I appreciate it. I'm one of those few lawyers that really loves what I do. I get to help great people make important decisions in their lives. So thank you for the support.
Michael actually reached out. Man, there's all this news about the FTC and non-competes. And a lot of people were celebrating across social media. Med Twitter was abuzz because non-competes have been eliminated. It is the death of non-competes. Physicians everywhere are freed. And then Michael is kind of this lone voice in dissenting opinion in the woods. He has a very good insight on the FTC ruling. He's been actually talking about it for even longer than, since before it kind of popped into So he reached out, and we're on the show today to talk about non-competes and what does this FTC ruling really mean or potentially mean.
Yeah, I think some of the excitement is certainly justified, right? But it's a little bit premature. Also, we should say we're filming this on April 29th of 2024. So depending on when you're listening to this, make sure you understand what has happened since then. So There's going to be a lot of changes. But just to kind of kick us off, the FTC, the Federal Trade Commission, passed a rule last week that banned non-competes for almost all employed persons in the country. Okay. For the moment, it is not enforceable. Best case scenario, it would be enforceable in about 120 days. But there's going to be some legal challenges. There's already a few lawsuits that have been filed. Ultimately, I think this is going to work its way through the courts, and I'm a bit skeptical. Okay. I also want folks to know, like, I support the FTC banning non-competes, right? Everything else is about like how it might be problematic and might be, overturned and, all the problems with it. But I support that. The other nuance here is I support non-competes. This might be a bit of a dissenting opinion, but I support non-competes in the context of small business ownership. Stephen, if you and I, let's not be an anesthesiologist for a moment. Let's be some dermatologists. If we started a private practice together, I think it actually helps spur economic growth if you and I agree not to compete against each other, not to compete for patients, not compete in the same geographic area for a reasonable amount of time. That helps us grow and develop together. We might have different skills, different like business acumen, different things that we do well, and tying us together will help us grow and actually become a more successful practice. But for the vast majority of physicians, particularly those that are employed in large practice settings and mega hospitals and academic settings, what have you, I don't think that they make a lot of sense and should be removed.
And I think we're diverging already as to the limited use cases for when non-competes are helpful. So I was talking to my wife. It's been interesting how each field has kind of a slightly different take on non-competes, because from an anesthesia perspective, in some cases they are protective. I was telling her I worked at a hospital in kind of not rural Virginia, but a place that you probably wouldn't want to live there unless you had some kind of familial connections. It was a large tertiary hospital that had probably 20, 25 anesthesiologists. And for groups like that, the non-competes are protective, because for a large group to come in and take that contract, the hospital would lose all 20 or 25 anesthesiologists that worked at that facility. But obviously it's not that protective, because it happened to a huge hospital in Beaumont. That was a whole fiasco. It's been in the news. It happened in, I think, North or South Carolina for huge groups, right? And because of non-competes, you lose your contract, and it at least gets tied up in the court as to whether those anesthesiologists can stay working at that same hospital. So for the smaller to medium-sized anesthesia groups, they did have some value as well.
It brings up an interesting point specifically in anesthesia. The non-compete, let's back up and talk about non-competes, what that is for a moment, right? So non-compete typically speaks to a geographic restriction on where you can work, both during your employment, it applies to moonlighting gigs, and after you leave a job. So some folks, just back to basics for a moment, some folks say, hey, I terminated my contract. I don't care what's in there anymore. It doesn't matter, right? No, it does matter, because these clauses survive the end of a employment relationship and can last, a common one is 2 years. For example, 2 years and 20 miles from your primary practice location or every practice location. There's a bunch of things we can talk about in there. But what the FTC ruling maybe wasn't crystal clear on was what other similar restrictions can still be enforced. For example, in anesthesia, let's say your group, you have a small group of 5 or 10, and you service one hospital. Okay. That contract probably has a non-compete, but the more powerful clause is probably the non-solicit clause that prevents a physician from practicing at the same facility upon exit, from taking advantage of that, that close relationship that physician developed with, frankly, the client of the practice. Okay. So in that case, this non-compete ban might not remove the non-solicit clause. And I think non-solicit clauses might be beefed up in physician contracts moving forward, might be the primary protective source for businesses looking to avoid, supposed unfair competition. So, for example, backing up on a non-solicit clause for a moment, the non-solicit clause speaks to what the physician can do with the valuable relationships that are developed during the employment.
Okay.
For anesthesia, the relationship isn't really with the patients. Like, that's not really a thing, but the relationship between the hospital, the facility, and that physician is very valuable. There's a lot of situations where that hospital would love to cut out the middleman, if you will, the practice, and just contract with you directly. They could probably get a little bit of a discount, or maybe if they could pay you a little bit more, disrupt the practice, and then maybe bring you in-house instead of having the separate private practice. There's a valuable business relationship there. So the non-solicit clause sometimes affects your ability to leverage, to use those business relationships that are developed during your employment. In our dermatology example, there's often a non-solicit clause that applies to all referral sources. So imagine you've been working at a place for 3 years, you want to leave, and you want to bring your patients somewhere else. The primary care docs or whoever you receive patients from, you want them to still send you patients at your next place. Maybe you want to maintain hospital privileges at the same hospital that you previously had, or the ASC, or wherever you did your procedures, right? Even if the non-compete is removed, the non-solicit clause that restricts your ability to use those relationships to still receive patients from those referral sources, or to bring your former patients into your new practice, or to still, practice at whatever facilities you previously practiced at for the employer. It's unclear whether those clauses would be effective. Does that make sense?
I know I've seen non-solicit in, but I've always focused on the non-compete. I didn't understand that. Wow.
Yeah, there's a lot of employers that are more than happy to waive the non-compete. And physicians will come to me, they say, hey, I already negotiated my contract. They removed the non-compete. I won, dude. Tell me everything is okay in this contract. And I'm like, goodness, no. Like, the non-solicit was the most problematic piece. Probably the best example of this is OMFS, oral surgeons. Mm-hmm. Okay. An oral surgeon, gets their patients from all of the, family practice dentists in a geographic area. Usually there's not like dozens of them. There's only a handful, right? So, or even sometimes just like one or two in an area. And then, all of the dentists, or a large portion of the dentists in a geographic area, refer to that oral surgeon. So the geographic restriction, you could remove that for the oral surgeon, but if that oral surgeon can't receive patients from any of the dentists that previously sent them patients, functionally, who cares about the non-compete, because the non-solicit is going to be even worse. But yeah, removing the non-compete doesn't make physician contracts like super safe or easy. It actually could add another layer of complexity to these relationships.
Can you explain, how do we get to the point where this even came up, that we're going to ban non-competes? Like who put those gears in motion? So
it kind of started with Jimmy John's. Kind of silly stories. Yeah. So
freaky fast delivery.
Yes, freaky fast. So that's Jimmy John's, right? I don't know all the catchphrases.
I think so.
So Jimmy John started having non-compete clauses for their sandwich makers. These are folks that are making $10, $12 an hour or less, and they, to become an employee there, Jimmy John's was making them sign a 2-year, 4-mile non-compete, saying you couldn't work in a similar type facility, restaurant, what have you, for a period. And the FTC, let's define FTC for a moment too, and then we'll get back to that. But the FTC, is called the Federal Trade Commission. This is a federal agency that is set up by Congress, and the directors, the commissioners of the FTC are appointed by the president. They're confirmed by the Senate. Okay. But they are tasked with protecting American consumers, American workers, from anti-monopolistic behavior, from just unfair trade practices. So they started looking at this. They said, this is exceedingly unfair. Jimmy John shouldn't be putting non-competes on their sandwich makers. Another example of an overnight worker that, like a security guard, that had a non-compete. Someone who's working, the night shift making minimum wage that now has a non-compete. It's like, this is silly, right? So the FTC did not have physicians specifically in mind when they, came about with this non-compete ban. It was really the lower to middle wage workers that were just really being taken advantage of. They also noticed that the legal steps that an individual would need to take to try to challenge a non-compete in courts was just cost prohibitive. They can't bring this on, right? Even for me, when I counsel a physician, what's it going to cost to challenge this non-compete? Usually I'm quoting 20 to 35K, maybe more, just to fight it. And then we're talking, 6 to 9 months at best. These best case scenarios. So think about someone who's making, 50 to 100K a year. They're never going to have that money. So, they passed a rule that said non-competes are unenforceable for essentially all employees. But that's kind of how the rule came into effect. There's individual states that have started passing, similar rules. Minnesota was the most recent. California's never had non-competes, by the way. 125 years, they haven't had non-competes. Them alone, they're like the 6th biggest economy in the world if they were a separate country. They've never had non-competes. So all of the discussion about how terrible non-competes are, they're going to upend the entire economy and create chaos. California has never had these and everything's okay. It's not chaos. So that's kind of the background.
Now, you said non-competes for employees, but who else would a non-compete be for?
So the FTC in their ruling created a carve-out for senior executives. These are folks who are highly compensated, who they believe had the negotiation leverage to trade a non-compete for something of value. Okay, we'll get into that as a potential carve-out. There's also discussion about my small business owner example, or in the context of buying and selling a business. For example, Stephen, if I wanted to buy your podcast from you, I don't think I'm going to be able to pull that off. But let's say you wanted to sell your podcast.
You can't afford us.
I can't. My lawyer fees are not high enough for that. But let's say for a hypothet, if I was going to buy this podcast from you, I would need a legal protection from you just starting a new podcast the next day and calling it something similar and doing the same thing. I would be buying nothing if you could immediately compete with me. So in the context of buying and selling businesses, it makes sense because, the value of the business that you created, just goes away if the buyers are fearful that you can, recreate the same thing 5 minutes later across the street. So those are two starting points for carve-outs. We should also talk about whether the FTC has authority over not-for-profit institutions and for-profit institutions. For-profit is hard, yes, but not-for-profit is a bit up in the air.
Why would the FTC not be over nonprofit?
Yeah, so part of their charter is to regulate commerce, regulate trade, unfair competition, and they're a bit limited in how they can regulate not-for-profit entities. However, there's a bit of a carve-out here. It's kind of an open question in law, what is a not-for-profit for the purposes of tax code, tax law, versus what is a not-for-profit in who can be regulated by the FTC. The FTC says that solely leaning on your not-for-profit status is not enough to leave you outside of their purview. Okay?
Okay.
So, as you know, a lot of mega health systems are set up technically as not-for-profit institutions. We can all chuckle about this a bit because they're massive and they create a lot of profits. It's just not for shareholders. It's often for C-suite folks and in other ways. Okay.
Oh, okay. They don't have shareholders, but somebody's making a lot of money.
Yeah, they have a board. They have a board of directors, but the profits created by your typical mega health do not go to shareholders. You can't buy, like, if you own a stock of Tesla, right? They make money, you get a corporate dividend. A not-for-profit institute, you can't do that. Like, there's no way to really buy in. That's kind of the whole point.
Gotcha.
So, a lot of these systems are set up that way for tax advantages, but they really operate like day to day, they operate more akin to for-profit institutions. So the FTC in their commentary around creating this rule touched on that issue. And they said, look, we believe that we can still regulate not-for-profit entities if they are, the language is something like, sufficiently in pursuit of commerce, of profit, that sort of thing. But, the AHA, the American Hospitals Association, has been speaking about this quite a bit because some of their members are not-for-profits and some of their members are for-profits. HCA, for example, mega group, right? They're technically for-profit. So they don't, we see it on our side in the law firm. They don't really operate differently than a similar mega health entity that is technically not for profit. And I actually see the point. They should not be regulated, frankly, differently than another mega health that is technically set up as a not for profit. But currently, there's a bit of an open question there. It'll be interesting how that shakes out. I'm sure the courts will have something to say about it.
That's fascinating. Now, a lot of not-for-profit hospitals, though, will contract out to physician groups. So how does that work? You're employed by a group. Is there any trickle down of we work for a nonprofit as a group, or how would that be an issue?
It would almost certainly apply to, so the FTC non-compete rule, assuming that it becomes enforceable, would almost certainly apply to the independent physician group that is contracting with the hospital. Okay. That would be technically a private practice. They're sometimes, like, for example, an anesthesia group, they're typically owned by the physicians. Obviously, there's some private equity involvement, but at times, they should be owned by the physicians, and then, the physicians get the profits from that. So that would be considered a for-profit and would be subject to the FTC's purview.
Nice. We mentioned a couple carve-outs, but I remember back with the student loan fiasco, and there was like, we're going to forgive X amount of student loans, but then there was a carve-out for wage earners if you make more than this amount. And typically, physicians are not beneficiaries of these sweeping legislature changes. Is there any thoughts of them saying, hey, physicians, they're a different category, and we want to eliminate them from this ruling?
Yeah, so as the rule currently stands, there is a carve-out for what's called senior executives. Senior executives, there's two elements to it. One, you got to make more than, I think it was $150,000, basically. Okay, so that's going to apply to pretty much every physician unless you're like kind of part-time or something like that. Number two, you have to have some sort of managerial director, supervision type role. You got to be making decisions. And that gets a bit questionable for physicians. Like, where is the line on that? If you're supervising a nurse practitioner or other nurses around you, your MA, your CRNAs, is that enough to meet that definition of a senior executive? It probably shouldn't, right? But look, if you're in a C-suite position, let's say you're the medical director of that group or something like that, maybe you start to get in a little bit more of a gray area. The nice thing about their ruling, though, is they said that from the date of that the rule comes into effect, past contracts for senior executives could maintain non-competes. But any future contracts, any new relationships that are created cannot have non-competes. So while they did carve out an exception for senior executives, it's more of a matter of time for some of those contracts to either be renewed or might encourage senior executives to change jobs because now they would have a better non-compete and maybe have a little bit more leverage against their current employer. If they had a competing job, they said, hey, you want to keep me under this non-compete or you want to hire someone else that doesn't have one? Listen to me. I want XYZ. Be an interesting place for a negotiation. But yeah, so the carve out for senior executives is quite limited right now. So hasn't been a main focal point for our analysis of the law's impact in the firm.
So I guess what else do we need to know about this ruling? Do we just sit tight and wait for it to play out, or is anything we should look for?
So first things first, as of April 29th it's not enforceable. Okay. So the headlines that said they're all banned, that's a bit premature. Okay. The headline should read that best case scenario in 3 months they're banned, but subject to potential legal scrutiny. Okay. Right now in the firm, we haven't changed how we evaluate and negotiate non-competes. For now, we are still working under the assumption that they are enforceable as written, and we negotiate them accordingly. Just give you a little context. What we expect to see happen is that there'll be multiple legal challenges. For example, the U.S. Chamber of Commerce, it's a big business group. They filed a lawsuit asking for courts to overturn this rule, to make it unenforceable. They've argued that the FTC doesn't have the power to do this type of rule, that it's actually unconstitutional because it goes beyond what this particular federal agency was set up to do. We could go into the constitutionality of that, but there's like a whole background in like states' rights and all that crap. So we'll leave that to the side for the moment. But the argument is that the FTC went too far, that they don't have the power to do this. They also, have a couple other arguments, like it was unfair to not exclude certain industries, like certain industries should have special consideration because of their unique nature, blah, blah, blah. And obviously folks like the AHA and other large medical groups, not the AMA, but others have also advanced that say, hey, can we carve out healthcare? Basically, every major industry is asking for a carve out, like financial services, real estate, healthcare. I'm sure someone in construction is asking for this too. Like everyone's trying to carve themselves out from this rule. But that's going to be worked through the courts. We suspect, I think the prevailing expectation is that at least one of these cases is going to result in the rule being paused. Okay, what's called a preliminary injunction, paused for a moment as these lawsuits work their way through courts. The U.S. Chamber of Commerce case was filed in the Eastern District of Texas, and historically, some of the more, conservative-leaning, groups trying to push back against, federal agencies expanding their scope have been through either Texas or Louisiana, and then through the U.S. Fifth Circuit Court of Appeals for constitutional law nerds and folks who follow courts. It's usually
where's the Fifth Circuit? Where is that?
Based in New Orleans. Based where I'm from. I went to law school in Tulane and in New Orleans, and it was all right there. There's a lot of law in New Orleans.
So what you're telling me is these groups can pick and choose what court to try stuff in, and they try it in specific courts because of the demographic or the makeup of. Wow.
Correct. So they know that they have the best chance to achieve a preliminary injunction, to pause it. Okay. And they have the best chance to get it to the Supreme Court to really push up this rule. I don't think it's a very debatable issue right now, but the U.S. Supreme Court is in its most conservative makeup in recent memory. It's really 6-3, and I don't even think Justice Roberts, probably the sixth one, the most central one, would maybe support this. But I think ultimately what's going to happen is there's going to be a preliminary injunction. It's going to make it to the U.S. Fifth Circuit. They're going to say something about that, and then it's going to go to the Supreme Court. And I have my doubts that a court in its current makeup is going to be supportive of a federal agency overruling, a relatively meaningful aspect that has typically been decided in each state.
Wow.
So the Supreme Court matters. If the Supreme Court was different, if it was 5-4 the other way, I think my advice this last, 10 minutes of conversation, 20 minutes would have been very different. It might have been very different, but we'll see what happens. Okay. I would love to be wrong on all of this, by the way. Like, I hope the future says that, Michael was wrong and we're all looking back at this and, non-competes have been banned for, the vast, if not all, employed folks. But I think that's how it's going to go down, but we'll see.
Wow. So, but on a positive note, I imagine that for contract negotiations, this does provide some leverage or maybe a crack in the foundation of these institutions, maybe?
I agree with that. I think that when we ask now for modifications or potential removal of non-competes, that we'll start talking about this more, talking about the ban, how they're disfavored, and you're asking for some relief. And I think that more employers might be willing to explore those or feel a little bit more pressure from physicians asking about this on a regular basis. I also think it's just bringing into the national conversation a really important issue, just about fairness for workers' rights. So I think this will help individual states as they might want to change the laws in their state. Minnesota just did this. New York was very close to doing it, but I believe that the issue in the New York bill, New York was about to ban non-competes and actually passed their state house and their state senate and was vetoed by the governor, who was actually a Democrat. But the issue there, I think, is that it applied to small business owners as well and in buying and selling businesses. So I think that was the concern. Look into that a little bit deeper. But I think a lot of states are now going to take a closer look at their rules and see if they can pass something. I'm also seeing potentially cities getting involved. So the New York City Council is looking at this, seeing if they can pass a non-compete ban for the city of New York. That's like, I don't know, 10 or 15 million. That's a lot of people. Like that'd be an interesting one, right? If individual cities could then do maybe what the state or the federal government, cannot right now, that'd be really fascinating. So it'd be interesting if New York does this, if many of the major cities that are maybe their city councils are primarily run by liberals that are maybe more interested in this typically than others, might be passing similar rules. We'll see. I don't know where this is going to go. It'll be very interesting. I hope I'm back on the podcast many times, but if it's another 6 to 12 months, it'll be interesting what happened here.
Absolutely. Well, Michael, thank you for coming on and sharing. If you want to know more information, so Michael, his social media, you're not going to see TikTok dances or viral music, but he consistently just provides facts. It's all helpful, all relevant. Had considerable growth because, again, he just puts out good quality content. Where can people go to hear more from you?
Check me out at Physician Contracts on Instagram. I have so much fun with it, by the way. You'll see me, I have a few minutes. I got a backwards hat and I'll talk about the thing that was most interesting about my day. Often I'm just sharing, some of the main issues that pop up in my day-to-day practice. And just trying to share as much information as possible. So check me out at Physician Contracts on Instagram. I also have a website, Michael Johnson Legal. That's for the law firm. And I'm soon creating a more built out physician contracting course, learning about these issues. That's going to be at physiciancontracts.com.
That's fantastic. Well, Michael, let's jump into this next thing that you're starting. You are creating a course. I imagine you've had, I don't need to imagine, you've had several years of experience negotiating these contracts. You've provided invaluable advice on different platforms, this one included. You have a blog, but you are now distilling some of that information into a course targeting physicians that are looking into starting their job and having to look at these contracts. Can you tell us about this next venture?
Yeah, absolutely. So I've just really enjoyed the Instagram presence.
Thanks so much for tuning in this week on the Black Doctors Podcast. If you enjoy the content that we're bringing, please go ahead and share with somebody else that you think can learn from it and benefit from this. If you haven't already, leave us a review. I get those reviews, and it does provide some encouragement, and know that this message, these vibes, this support, this community is working, it's growing, and definitely appreciate your support in that way. Reviews are free. Drop some stars on us. We appreciate it. We're actually, growing to the point that we dip on and off of the top, I think it's 200 list of podcasts in the health and wellness space. So that's exciting. An email every week. It's like, oh, you were in the top 200. And usually not anymore. It's just like really fleeting, but we are growing. Thank you so much for your support in that. Thanks for tuning in to Black Doctors Podcast. We're here because representation matters.